In case you are a party to an arbitration agreement, or if the arbitration agreement is part of some contract and you see that some dispute is arising with respect to supply of good, performance of the contract, or any payment related to the contract, and you see that the dispute is arising, and in some time or without giving you any intimation, some further step can be taken by the other side which will impinge upon your rights, then what is the remedy or the quick remedy that is available to you under the arbitration law? So the lawmakers thought about it and they have given section 9 under the Arbitration and Conciliation Act of 1996. So this section 9 provides that the regular court will have the power to grant interim relief to a party where there is an arbitration agreement, either before the commencement of the arbitration or during the arbitration or even after the award is passed but till the award is executed. So at these three stages, a party has a right to get an interim relief or interim order from the regular court and not from the arbitrator itself. So let us understand that what is the process to get an interim relief if in case some dispute is arising between you and the other side of the contract which has arbitration clause. So to begin with, first of all, there has to be some formal communication between both the parties or from one side at least that there is some dispute to which you agree or that party does not agree or that party agree you do not agree. Means there is a dispute between the party and in lieu of that dispute the other side is ready to take some action like stopping your payment, realizing any guarantee that you have given, or selling off any property which is a common asset, or anything just imaginable in your case that can happen. Now if you see that dispute is arising, then the first step that you have to take is to invoke the arbitration clause and show the intention that you want to pursue an arbitration in that matter. So issue the notice that arbitration should be done to resolve this dispute. Or if there is a clause in your arbitration agreement that firstly the dispute will be tried to be settled amicably and then the arbitration clause, then invoke that clause saying that let's settle the dispute amicably. And if you see that a reasonable time has passed but the other side is not responding, then you can say, since you are not uh, resorting to the settlement by amicable method, then in that scenario you get the sufficient intention that you want to invoke the arbitration clause. Just send them a letter that within a reasonable time let's appoint the arbitrator, let's begin the arbitration proceeding. And if the other party is still not resorting or not replying to your communication, then in that scenario you have shown your intention to do the arbitration. Once this intention is established, then you can directly approach the jurisdictional court and file an application for getting an interim relief based on your suspicion or assumption that what kind of action the other side can take and cause loss to you, or in any manner as things are enumerated in section 9, that if you think that any property, movable item, or any item can perish, in all those situations you will have to explain in your interim relief in your application under section 9, and then you can seek a interim relief. So what is the requirement to get the interim relief? So as in all cases, the requirement to get an interim relief is to establish a prima facie case that there is a dispute between the party, there is an arbitration clause, the other side is not uh, helping or the other side is not ready to resolve the dispute despite you invoking the arbitration clause, and that this dispute will result into causing some damage or loss to you if the interim relief is not granted. The second thing will be, the first thing is prima facie case, the second is the balance of convenience. So the court will see that the balance of convenience is on both the side or is more in your favor, and granting an interim relief will not cause any kind of harm or loss to the other side. And the third ground is irreparable loss. So from your facts and circumstances, you would prove that if the interim relief is not granted, then you would suffer an irreparable loss. Let us say that some property is going to be disposed by the other side, through which you could have secured your payment. Or let us say that your bank guarantee is going to be realized by the other side. Or let us say you had given some loan to the other side, and out of that loan some movable or immovable assets were created, and you want to stop the other side from disposing that asset or alienating that asset in any way. So circumstances are numerous. Or let us say that other is a government side and it is ready to start some recovery proceeding against you, or it is demanding extra money or extra amount, which was actually agreed between you with respect to the revenue sharing out of the contract. So these are the circumstances where irreparable loss may be caused, and you can establish your case within these three grounds: prima facie case, number two, balance of convenience, and irreparable loss. So these are the things which you will be required to prove in your case. Moving to the next issue is that the court which will have the jurisdiction to entertain such application under section 9. So almost all the arbitration agreement or the arbitration clause which is the part of the contract will have a jurisdiction clause, that all the disputes will be subject to the particular city, jurisdiction of a particular city. So let us say that the contract or the arbitration clause says that the seat of arbitration will be in Delhi. So the courts of Delhi will have the jurisdiction to exercise its power under section 9. If the arbitration clause says that the seat of arbitration will be Kolkata, then the court of Kolkata will have the jurisdiction to exercise power under section 9. What if the arbitration clause is silent with respect to the seat of the arbitration? Then in that scenario, the place where the contract was executed, then that will prevail, and in that scenario you can take that place as the seat jurisdiction or the seat of arbitration, so that you can invoke section 9 at that place. So all these things will be required to be mentioned in your pleading of the application under section 9. When it comes to the decision that in which court, now we have decided the city, that in which city you will file the case, then it will come that which court will have the jurisdiction. Means the civil judge will have the jurisdiction, the district judge will have the jurisdiction, or the high court will have the jurisdiction. So in that scenario, it depends from state to state. You will have to look that on the basis of the amount of the arbitration agreement, which court has the jurisdiction to entertain. So now normally it is the commercial court. After the enactment and enforcement of the Commercial Courts Act, it is the commercial court which has the jurisdiction to entertain this thing. In some state it may be the commercial division of the high court, or even the normal district commercial court will have the jurisdiction. Like in Uttar Pradesh, for all kind of arbitration issues, the commercial court of the district will have the power. And in states like Delhi, the Delhi high court may have power of against the depending on the amount. If the claim is above 2 cr, then the high court may have the power, or below that the local court may have the power. So depending on the seat of arbitration, first the this territorial jurisdiction has to be seen, and then the pecuniary jurisdiction has to be seen. Now you will get now suppose that you get an interim relief. If you have a good case, you will definitely get the interim relief. If you have pleaded well, you will get the interim relief. So what would be the tenure of this interim relief? So always keep in mind that when you are drafting the interim relief application under section 9, try to stretch it for the till the enforcement of the award. That is, for the period before the initiation of the arbitration, for the period during the arbitration, and for the period even after the award is passed. Let the other side oppose that, and you try to convince the court that why the interim relief from the court is required in the matter. So this will also depend on the facts of your case and the circumstances of your case. This has to come in your application and in your prayer, that for how long you want. And if in case you have not mentioned the time period, then it will be applicable only till the arbitrator is appointed, and then you again file an interim relief application before the arbitrator. And if the arbitrator will deny that, then you cannot go back again to the court, depending on the facts and circumstances. So moreover, in section 9, it has already been provided, certain circumstances or situation have been provided, that for what purpose or for what reason the interim relief can be sought under section 9 of the Arbitration and Conciliation Act, which are for the appointment of a guardian of a person of an unsound mind. So it may happen that some person entered into an arbitration clause, and then thereafter he became of unsound mind. In that situation also, a guardian can be appointed for the purpose of arbitration proceeding. And the interim measures can be sought in following circumstances. So number one is that for preservation or sale of any goods which are the subject matter of the arbitration. Number three is securing of any amount which is the subject matter of the arbitration. So now let us say that there was any payment which was due, or any payment which was left, or you made a part of that payment and the issue was settled, and after some time the other side comes and says, boss, there was a wrong calculation and you need to pay me this much, and if you will not pay me this much amount, then the bill which is pending to be paid by the other side to you, then it will adjust that amount in that. But you have a legal ground that is there is a waiver, or there is a acquiescence, or there has been laches in demanding such amount, and you think that the payment will be made to you by deducting that amount. In that scenario, you can approach the regular court which has the jurisdiction. The other ground is for the detention, preservation, or inspection of any property which is the subject matter of the arbitration. You can also make a prayer for the inspection or for appointment of a receiver of a property. So let us say that there was a joint venture business, because there was a business run by a joint venture, and in that joint venture there is an arbitration clause, and then there are certain rent or money or license fee or any kind of income that joint venture is making out of some asset. In that scenario, a receiver can be appointed, that all the income which the joint venture is making, that should be received by it. It may so happen in the case of the toll tax collection, where the toll is collected and you are let us say the developer, private developer, and you have a dispute with the government which says that you have to pay this much toll, or it is going to reacquire the toll or cancelling the toll. In that scenario, you are asserting that the toll period has still not concluded, or you have not recovered the amount which you had invested, but the government is ready to take over the toll. In that scenario, you can request that a receiver be appointed, so that whosoever will win, that party will get the money soon after the award. Otherwise, you will have to first win the arbitration, get an award in your favor, and then thereafter go for the execution and then for the recovery proceedings. And in the end, it has been provided that in any other situation where the court deems it fit, that it would be just and reasonable to grant an interim relief. So a wide discretion has also been given to the court. So if you can make out a good case through your pleading, through your facts and circumstances, then you can get an interim relief, and you can secure the payment, or you can secure your interest by getting an interim relief from the court under section 9. So this was all with respect to section 9. Hope this was helpful. Thank you so much for watching the video.